can be done to improve compliance with the detail.
I turn next to Lord Alton. David.
Thank you, Lord Chairman. Can I invite you, Sir Malcolm, to dive deeper into one or two of the specifics?
Yes.
Maritime security. I mean, how much does UNCLOS actually hinder or help maritime security? And human security and human rights, how much does it help or hinder?
Oh dear. This could take us to 11 o'clock. The words, maritime security, it's now a very fashionable phrase. And quite what it means is rather open-ended. It is a phrase that means very different things to very different people. For some, maritime security very much means national security. How do you protect your national interests, at sea, your security assets? For others, maritime security means, if you like, the safety of the seas themselves, the integrity of them, so environmental protection and things of this nature, fisheries conservation. These are all for others elements of maritime security. So we could spend a lot of time trying to unpack it, but that probably isn't where we need to go, though happy to spend more time doing that. What is increasingly clear, and again, doubtless we'll come back to this, is when you look back at the Law of the Sea Convention, from where we stand today, what were its chief preoccupations? Its chief preoccupations largely were to do with navigation and issues around navigation and access and exploitation of resources at sea. And so most of its provisions were focused on that. Has it got a lot to say, therefore, about security issues at sea directly, in a way that isn't, if you like, parasitic on ideas of freedom of navigation, particularly navigation for military vessels in traditional means? The answer is no, not really. When it comes to whether it says very much at all about human security at sea, and what do we mean by that these days, it has got extraordinarily little to say. It has got its classic provisions on the need to, the obligation on states to respond to those in distress at sea, which are, obviously of vital importance, and that reflects long traditions of the uses of the seas. The seas are a place which have always both inspired awe and fear in people. They are a site of huge danger. And, should we say, people have always understood the need to respond to people who are in distress at sea. This is reflected in the convention. But the details of how that plays out in practice, what it means, what the consequences of that are not touched on at all. The convention has got an awful lot more to say about protecting fish than it's got to say about protecting people. And, I think that is one of its huge flaws. It's worse than that. Not only does it not actually say very much that's helpful about it, because of the way it approaches, its zones of jurisdiction, the way it allocates flag state jurisdiction, etc., and says that the high seas are a place beyond, jurisdiction and so on, it makes it extremely difficult to apply other areas of law, such as human rights law and other things, at sea. So it's not only that it doesn't say much about it, the way in which it is structured and the way it approaches jurisdiction at sea makes it extremely difficult to effectively extend human rights obligations and other obligations concerning the human person at sea to those people. At the end of the day, if a vessel is registered in a state that is not interested in, is not really interested in achieving compliance with human rights commitments, people on board those vessels are going to be extremely vulnerable, and they are.
Malcolm, thank you for that. I mean, all of us have been horrified looking at the situation of refugees, Rohingya refugees, for instance, or people in the English Channel or in the Mediterranean, whose lives are compromised and sometimes lost at sea as a result of there being so little by way of protection or jurisdiction. I was very struck in the earlier session that we had today when Professor Haynes said to us about the position of human rights. He said human rights is not a priority in UNCLOS. It didn't feature at all. There's total ignorance of human rights in UNCLOS. And he gave us an example of a Panamanian ship and involving a British woman, underage, who was sexually assaulted at sea, and the failure then to bring any kind of justice for her. Extraterritoriality, of course, does function in the United Kingdom in such cases, but not in this case. Is there more we could be doing about this? I mean, we are members of the United Nations Human Rights Council. Is that a place where we should be triggering a debate about human rights and its failure to feature in UNCLOS? And would it get anywhere?
The short answer is, I think, yes. Would it get anywhere? I think, yes. Because this is now recognised as a huge gap. And it does need, shall we say, careful thinking about how it can be filled in a way that doesn't do, shall we say, too much damage to other areas where you still need to have the integrity of those systems and structures. To give a practical example, there was a case, a set of views given by the United Nations Human Rights Committee earlier this year. And this concerned a situation in which an Italian military vessel had, for all practical purposes, stood off for too long while a vessel in the Mediterranean with Libyan migrants on it was in distress and ultimately sank, leading to the loss of a huge loss of life. It may have been as many as 400 people, possibly not as many as that. It did, in the end, go to the rescue, but it acted fully within the, if you like, within the theory of the law at the time. It was in the Maltese search and rescue zone. The vessel was in the high seas. The Italian vessel didn't, on the face of it, have any obligation, it said, to do anything at that point because it hadn't been officially notified that it was in distress, except that arguably it had, because the authorities in Rome had been told, and so they told the Maltese, so the Maltese then took some time to tell them. And in the end, the Human Rights Committee said, basically, this is a vessel, you knew it was there in the real world, you knew it was in distress, and you didn't do anything until it was too late, because you were waiting for someone to tell you to do it, because you didn't have to. Now, that actually, in some sense, is a very powerful argument. But what it then sort of suggests is that if you follow that route, any time any vessel of any state is in proximity to or knows that there may be a vessel in those circumstances, then it may have the obligation to rescue the people on board, to go to that situation, to sail in considerable distances. If it doesn't do so, these are all quite difficult things from a practical point of view. So what is really needed is something which are not looking at piecemeal solutions to these things, but looks at it more holistically and get a better sense of how human rights obligations ought to extend to sea. We tend to think it in terms of migrants drowning at sea and all the horrors that flow from that, but also in completely different contexts. Another very well-known one concerns the situation of those working in deep water fishing vessels, which may be at sea for very many years. The labour conditions on these things are truly terrible. Yet, who is regulating them? And for practical purposes, they either are unregulated or what regulation exists is not capable of effective enforcement. And that produces terrible abuses. And so on. And so there's a crying need to be able to do this, but in a way which is systematic. And not, should we, in my view, overforce existing categories in a way that is a little bit disingenuous at times and can cause damage. We've all seen how that has happened in the past.
Really helpful.
Thank you very much. I turn now